listening to the evidence in case something comes up and someone is discharged so that they could be substituted in. But unfortunately, you don't get to take off and be free, okay? We're going to keep you involved. Okay, we're ready to charge the jury at this time. That has been placed in your notebook. It's not necessary. Got court officers with them. All right. Be starting with page 9. Everybody got a copy of that in your notebook behind the next tab. They didn't mess with your personal stuff. It was just inserted in the notebook either by her or my secretary. She put it in. So she didn't go through your personal stuff for us. So she's got other things to do. So at this time, we'll do the next charge. Following that, we'll take a break. Then we'll take up closing statements, okay? Okay, ladies and gentlemen, the evidence in this case has been completed, and it is my duty now to instruct you further as to the law. The first-degree felony murder, especially aggravated kidnapping, aggravated rape, and first-degree premeditated murder. Counts 1 and 4 charge the defendant with the offense of first-degree felony murder under alternative theories. The offense of first-degree felony murder necessarily includes the lesser offenses of facilitation of first-degree felony murder, second-degree murder, facilitation of second-degree murder, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation of criminally negligent homicide. Counts 2 and 3 charge the defendant with the offense of especially aggravated kidnapping under alternative theories. The offense of especially aggravated kidnapping necessarily includes the lesser offenses of facilitation of especially aggravated kidnapping, facility of aggravated kidnapping, facilitation, kidnapping, facilitation of kidnapping, false imprisonment, and facilitation of false imprisonment. Counts 5, 6, and 7 charge the defendant with the offense of aggravated rape under alternative theories. The offense of aggravated rape necessarily includes lesser offenses of facilitation of aggravated rape, facilitation of rape, aggravated sexual battery, facilitation of aggravated sexual battery, and facilitation of sexual battery. Count 8 charges the defendant with the offense of first-degree premeditated murder. The offense of first-degree premeditated murder necessarily includes the lesser offenses of facilitation of first-degree premeditated murder, second-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation of criminally negligent homicide. The defendant pleads not guilty to each and every offense embraced in the indictment. Criminal responsibility for the conduct of another. The defendant is criminally responsible as a party to the offenses of first-degree felony murder, especially aggravated kidnapping, aggravated rape, and or first-degree premeditated murder, or any of the lesser included offenses if the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist in the commission of the offense or to benefit in the proceeds or the results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. A defendant who is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another if you find beyond a reasonable doubt that the other offense or offenses committed were natural and probable consequences of the original offense for which the defendant is found criminally responsible, and the elements of the other offense or offenses that accompanied the original offense have been proven beyond a reasonable doubt. With regard to counts 1 and 4, charging the defendant with murder and perpetration of kidnapping and rape respectively, this natural and probable consequences rule does not apply. There is no requirement that the killing be foreseeable in order to hold a defendant criminally responsible, only that the defendant intended to commit the alleged kidnapping or rape. In deciding the criminal responsibility of the defendant, the jury may also take into consideration any evidence offered that the defendant attempted to thwart or withdraw from any of the offenses that followed from the original offense. To find the defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for said offense or offenses committed by the conduct of another, you must find that all the essential elements of the offense or offenses have been proven by the state beyond a reasonable doubt. Facilitation of a felony. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant knew that another person intended to commit the specific felony, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And two, that the defendant furnished substantial assistance to that person in the commission of the specific felony. And three, that the defendant furnished such assistance knowingly. Counts 1 and 4, first-degree felony murder. Any person who commits first-degree felony murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant or one for whom the defendant is criminally responsible unlawfully killed the alleged victim. And two, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged kidnapping for count 1 or the alleged rape in count 4. That is, that the killing was closely connected to the alleged kidnapping in count 1 or rape count 4 and was not a separate, distinct, and independent event. And number 3, that the defendant intended to commit the alleged kidnapping, count 1, or rape, count 4. Count 1 charges the defendant, charges the offense of first-degree felony murder of Holly Lynn Bobo during the perpetration of or the attempt to perpetrate kidnapping. Count 4 charges the offense of first-degree felony murder of Holly Lynn Bobo during the perpetration or the attempt to perpetrate rape. Kidnapping and rape are defined for you within these instructions. Refer to those instructions. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof of such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged kidnapping or rape. The killing may precede, coincide with, or follow the kidnapping or rape and still be considered as occurring in the perpetration of the kidnapping or rape so long as there is a connection in time, place, and continuity of action. When one enters into a scheme with another to commit a kidnapping or rape and death ensues, all defendants are responsible for the death, regardless of who actually committed. The essential elements to constitute facilitation of a felony and first-degree murder have previously been set out in these instructions. Refer to these instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of first-degree felony murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of first-degree felony murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser-included offense. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant unlawfully killed the alleged victim, and number two, that the defendant acted knowingly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, you shall so report your verdict on your verdict form. If you have a reasonable doubt as to the element, if you have a reasonable doubt as to the defendant's guilt of second-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine the guilt or innocence of facilitation of second-degree murder, a lesser-included offense. Facilitation of second-degree murder. The essential elements necessary to constitute facilitation of a felony and second-degree murder have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of second-degree murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of second-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of reckless homicide, a lesser-included offense. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant killed the alleged victim, and number two, that the defendant acted recklessly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless homicide as charged in the indictment, then your verdict must be not guilty as to the offense, and then you shall proceed to determine his guilt or innocence of facilitation of reckless homicide, a lesser-included offense. Facilitation of reckless homicide. The essential elements necessary to constitute facilitation of a felony and reckless homicide have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of criminally negligent homicide, a lesser-included offense. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant's conduct resulted in the death of the alleged victim, and number two, that the defendant acted with criminal negligence. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of criminally negligent homicide, a lesser-included offense. Facilitation of criminally negligent homicide. The essential elements necessary to constitute facilitation of a felony and criminally negligent homicide have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt the defendant is guilty of facilitation of criminally negligent homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of criminally negligent homicide as charged in the indictment, then your verdict must be not guilty as to this offense. Counts 2 and 3. Especially aggravated kidnapping. Any person who commits an especially aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty, and 2A, that the confinement or removal was accomplished with a deadly weapon or by display of any article used or fashioned to lead the alleged victim to reasonably believe it was a deadly weapon. That's count 2. Or B, that the alleged victim suffered serious bodily injury, which was count 3. In this case, count 2 alleges especially aggravated kidnapping of Holly Lynn Bobo accomplished with a deadly weapon, and count 3 alleges especially aggravated kidnapping of Holly Lynn Bobo with serious bodily injury to Holly Lynn Bobo. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud. Although the law requires no specific period of time of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. Degree of confinement. To find the defendant guilty of the offense of especially aggravated kidnapping or any of its lesser included offenses, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense of first-degree felony murder, aggravated rape, and first-degree premeditated murder, and or their lesser included offenses as charged and or included in counts 1, 4, 5, 6, 7, and 8. In making this determination, you may consider all of the relevant facts and circumstances of the case, including but not limited to the following factors. A, the nature and duration of the alleged victim's removal or confinement by the defendant. B, whether the removal or confinement occurred during the commission of a separate offense. C, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. D, whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so. E, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in this objective. And F, whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged offenses of first-degree felony murder, aggravated rape, and first-degree premeditated murder, and or their lesser included offenses as charged and or included in counts 1, 4, 5, 6, 7, and 8, and was not essentially incidental to it, you must find the defendant not guilty of especially aggravated kidnapping. If you find from the proof beyond a reasonable doubt that the defendant is guilty of especially aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of especially aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of especially aggravated kidnapping. Facilitation of especially aggravated kidnapping. The essential elements necessary to constitute facilitation of a felony and especially aggravated kidnapping have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of especially aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of especially aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of aggravated kidnapping. Aggravated kidnapping. Any person who commits an aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty, and 2A, that the defendant possessed or threatened the use of a deadly weapon, that's count 2, or B, that the alleged victim suffered bodily injury. That's count 3. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud. Although the law requires no specific period of time of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. Here again, refer to the explanation of degree of confinement in the instruction on especially aggravated kidnapping. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to the offense, and then you shall proceed to determine his guilt or innocence of facilitation of aggravated kidnapping. Facilitation of aggravated kidnapping. The essential elements necessary to constitute facilitation of a felony and aggravated kidnapping have previously been set out in these instructions. Refer to these instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of kidnapping. Any person who commits the offense of kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. And number 2, that the removal or confinement was under circumstances that exposed the other to a substantial risk of bodily injury. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud. Although the law requires no specific period of time of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if at the time of confinement, if the time of confinement is significant, and the distance of removal is considerable. Here again, refer to the explanation of degree of confinement in the instruction on especially aggravated kidnapping. If you find from the proof beyond a reasonable doubt that the defendant is guilty of kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of kidnapping. Facilitation of kidnapping. The essential elements necessary to constitute facilitation of a felony and kidnapping have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of false imprisonment. False imprisonment. Any person who commits the offense of false imprisonment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant removed or confined another unlawfully so as to interfere substantially with the other's liberty, and number 2, that the defendant acted knowingly. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud. Although the law requires no specific period of time of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. Here again, refer to the explanation of degree of confinement in the instruction on especially aggravated kidnapping. If you find from the proof beyond a reasonable doubt that the defendant is guilty of false imprisonment, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of false imprisonment as charged in the indictment, then your verdict must be not guilty as to the offense, and then you shall proceed to determine his guilt or innocence of facilitation of false imprisonment. The essential facilitation of false imprisonment. The essential elements necessary to constitute facilitation of a felony and false imprisonment have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of false imprisonment, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of false imprisonment as charged in the indictment, then your verdict must be not guilty as to this offense. Counts 5, 6, and 7, aggravated rape. Any person who commits the offense of aggravated rape is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. And number 2, A, that force or coercion was used to accomplish the act and the defendant was armed with a weapon or any article used or fashioned in a manner to lead the alleged victim reasonably to believe it was to be a weapon, that is to count 5, or B, that the defendant caused bodily injury to the alleged victim, that's count 6, or C, that the defendant was aided or abetted by one or more persons and that the force or coercion was used to accomplish the act, that's count 7. And number 3, that the defendant acted either intentionally, knowingly, or recklessly. In this case, count 5 alleges aggravated rape of Holly Lynn Bobo by force or coercion with a deadly weapon. Count 6 alleges aggravated rape of Holly Lynn Bobo with bodily injury. And count 7 alleges aggravated rape of Holly Lynn Bobo while the defendant was aided or abetted by one or more persons and that force was used to accomplish the act. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of aggravated rape, a lesser included offense. Facilitation of aggravated rape. The essential elements necessary to constitute facilitation of a felony and aggravated rape have been previously set out in these instructions. Refer to those instructions here. You find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of rape, a lesser included offense. Rape. Any person who commits the offense of rape is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number 1, that the defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant, and number 2, A, that force or coercion was used to accomplish the act, or B, that the sexual penetration was accomplished without the consent of the alleged victim and the defendant knew or had reason to know at the time of the penetration that the alleged victim did not consent, and 3, that the defendant acted either intentionally, knowingly, or recklessly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of rape, a lesser included offense. Facilitation of rape. The essential elements necessary to constitute facilitation of a felony and rape have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of rape, you will so report your verdict on your verdict form. If you have reasonable doubt as to the defendant's guilt of facilitation of rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of aggravated sexual battery, a lesser included offense. Aggravated sexual battery. Any person who commits the offense of aggravated sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number 1A, the defendant had unlawful sexual contact with the alleged victim in which the defendant intentionally touched the alleged victim's intimate parts or the clothing covering the immediate area of the alleged victim's intimate parts, or B, that the alleged victim had unlawful sexual contact with the defendant in which the victim intentionally touched the defendant's or any other person's intimate parts or the clothing covering the immediate area of the defendant's or any other person's intimate parts. And 2A, that force or coercion was used to accomplish the act, and that the defendant was armed with a weapon or any article used or fashioned in a manner to lead the alleged victim reasonably to believe that it to be a weapon, or that the defendant caused bodily injury to the alleged victim, or C, that the defendant was aided or abetted by one or more persons and that force or coercion was used to accomplish the act, and number 3, that the defendant acted either intentionally, knowingly, or recklessly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated sexual battery, you will so report on your verdict only. If you have a reasonable doubt as to the defendant's guilt of aggravated sexual battery as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of aggravated sexual battery, lesser included offense. Facilitation of aggravated sexual battery. The essential elements necessary to constitute facilitation of a felony and aggravated sexual battery have been previously set out in these instructions. Refer to these instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated sexual battery as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of sexual battery, a lesser included offense. Sexual battery. Any person who commits the offense of sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number 1A, the defendant had unlawful sexual contact with the alleged victim in which the defendant intentionally touched the alleged victim's intimate parts or the clothing covering the immediate area of the alleged victim's intimate parts, or B, that the alleged victim had unlawful sexual contact with the defendant in which the victim intentionally touched the defendant's or any other person's intimate parts, or the clothing covering the immediate area of the defendant's or any other person's intimate parts, and 2A, that force or coercion was used to accomplish the act, or B, that the sexual contact was accomplished without the consent of the alleged victim and the defendant knew or had reason to know at the time of the contact that the alleged victim did not consent, and 3, that the defendant acted either intentionally, knowingly, or recklessly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of sexual battery as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of sexual battery, a lesser included offense. Facilitation of sexual battery. The essential elements necessary to constitute facilitation of a felony and sexual battery have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of sexual battery, then you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of sexual battery as charged in the indictment, then your verdict must be not guilty. Count 8, first degree premeditated murder. Any person who commits the offense of first degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant unlawfully killed the alleged victim, and two, that the defendant acted intentionally. A person acts intentionally when it is that person's conscious objective or desire to cause the death of the alleged victim, and three, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of murder in the first degree, then it shall be your duty after a separate sentencing hearing to determine whether the defendant will be sentenced to death, life imprisonment without the possibility of parole, or life in prison. But you will not consider punishment for this offense at this time. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree premeditated murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of first-degree premeditated murder, as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of first-degree premeditated murder, a lesser-included offense. Facilitation of premeditated first-degree murder. The essential elements necessary to constitute facilitation of a felony and premeditated first-degree murder have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of first-degree premeditated murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of premeditated first-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser-included offense. Second-degree murder. The essential elements necessary to constitute second-degree murder have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of second-degree murder, as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of second-degree murder, a lesser-included offense. Facilitation of second-degree murder. The essential elements necessary to constitute facilitation of a felony and second-degree murder have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of second-degree murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of second-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of voluntary manslaughter, a lesser-included offense. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant unlawfully killed the alleged victim, and two, that the defendant acted intentionally or knowingly, and three, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of voluntary manslaughter, a lesser included offense. Facilitation of voluntary manslaughter. The essential elements necessary to constitute facilitation of a felony and voluntary manslaughter have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of voluntary manslaughter, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of voluntary manslaughter as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. Reckless homicide. The necessary elements to constitute reckless homicide have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of reckless homicide, a lesser included offense. Facilitation of reckless homicide. The essential elements necessary to constitute facilitation of a felony and reckless homicide have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. Criminally negligent homicide. The essential elements necessary to constitute criminally negligent homicide have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you will so report your verdict on your verdict form. You have a reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged in the indictment, and your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of criminally negligent homicide, a lesser included offense. Facilitation of criminally negligent homicide. The essential elements necessary to constitute facilitation of a felony and criminally negligent homicide have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of criminally negligent homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of criminally negligent homicide as charged in the indictment, then your verdict must be not guilty as to this offense. Definitions. Where appropriate, the following definitions apply in these instructions. You shall refer to these definitions when considering any of the offenses embraced in the indictment, if so specified, or only to limited offenses, if so specified. For the offenses and lesser included offenses, other than facilitation, of first-degree felony murder and first-degree premeditated murder only. Here, intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is a person's conscious objective or desire to engage in the conduct or cause the result. Here, knowingly means that a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally, as defined above. Here, recklessly means that a person acts recklessly when the person is aware of, but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly as defined above. Here, criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly as defined above. For the offenses and lesser included offenses of especially aggravated kidnapping only. Here, knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of a person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. For the offenses and lesser included offenses of aggravated rape only. Here, intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or to cause the result. Here, knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Here, recklessly means that a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Sexual penetration means sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusion, however slight, of any part of a person's body or of any object into the genital or anal openings of the alleged victims, the defendants, or any other person's body, but emission of semen is not required. Cunnilingus means a sex act accomplished by placing the mouth or tongue on or in the vagina of another. Fellatio means a sex act accomplished with the male sex organ in the mouth or lips of another. Intrusion into the alleged victim's mouth is not required. Coercion means threat of kidnapping, extortion, force, or violence to be performed immediately or in the future, or the use of parental, custodial, or official authority over a child less than 15 years of age. Victim means the person alleged to have been subjected to criminal sexual conduct. An aider and abettor is one who advises, counsels, procures, or encourages another to commit a crime. Sexual contact includes the intentional touching of the alleged victims, the defendants, or any other person's intimate parts, or the intentional touching of the clothing covering the immediate area of the alleged victim, the defendants, or any other person's intimate parts, if that intentional touching can be reasonably construed as being for the purpose of sexual arousal or gratification. Intimate parts include the primary genital area, groin, inner thigh, buttock, or breast of a human being. For the offense of facilitation of a felony only. Here, knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct. The person is aware that the conduct is reasonably certain to cause the result. Here, the requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intent means that a person acts intentionally with respect to the nature of the conduct or the result of the conduct when it is that person's conscious objective or desire to engage in the conduct or cause the result. For any of the offenses, deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Force means compulsion by the use of physical power or violence. Fraud is defined as the term is used in ordinary conversation and includes but is not limited to deceit, trickery, misrepresentation, and subterfuge. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, and mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. Unlawful pointing of a deadly weapon at an alleged victim is physical force directed toward the body of the victim. Deliberation, order of consideration. In reaching your verdict, you shall first consider the offense charged in count 1 of the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, then you shall proceed to consider whether or not the defendant is guilty of the next lesser included offense in the order from greatest to least within the count of that indictment. You shall not proceed to consider any lesser included offense unless you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the defendant's guilt, of the guilt of the defendant, as to all offenses charged and included in that count of the indictment, you shall return a verdict of not guilty on that count and then proceed to the next count of the indictment. You'll do that through the 8 counts. Identity. One of the issues in this case is the identification of the defendant as the person who committed the crime. The state has the burden of proving identity beyond a reasonable doubt. Identification testimony is an expression of belief or impression by the witness, and its value may depend upon your consideration of several factors. Some of the factors which you may consider are: 1, the witness's capacity and opportunity to observe the offender. This includes, among other things, the length of time available for observation, the distance from which the witness observed the lighting, and whether the person who committed the crime was a prior acquaintance of the witness. The degree of certainty expressed by the witness regarding the identification and the circumstances under which it was made, including whether it is the product of the witness's own recollection. Number 3, the occasions, if any, on which the witness failed to make an identification of the defendant or made an identification that was inconsistent with the identification at trial. 4, the occasions, if any, on which the witness made an identification that was consistent with the identification at trial and the circumstances surrounding such identification. And 5, any other factors fairly raised by the evidence. Again, the state has the burden of proving every element of the crime charged, and this burden specifically includes the identity of the defendant as the person who committed the crime for which he is on trial. If after considering the identification testimony in light of all the proof you have a reasonable doubt that the defendant is the person who committed the crime, you must find the defendant not guilty. Expert witness. Previously, I instructed you concerning expert testimony. In addition to my prior instructions, you are instructed that in giving his or her opinions, some expert witnesses may have testified that he or she took into consideration certain statements made by other persons. Because the statements of other persons were made outside the courtroom, they may only be used for you. They may only be used by you only for evaluating the expert witness's opinion, testimony, and cannot be relied on as proof of the truth of the matters asserted in those statements. Credibility and impeachment of witnesses. Previously, I've also instructed you concerning credibility and impeachment of witnesses. In addition to my prior instructions, you are instructed that a promise of leniency or other favorable agreement is a factor you may consider in determining the credibility of the witness. Evidence has been presented that witnesses testifying against the defendant on behalf of the state of Tennessee have been offered/granted immunity for prosecution for criminal acts committed by them. You must carefully evaluate the weight and credibility of the testimony of any witnesses who may have been induced by agreements with the state to testify against the defendant. You are further instructed that a witness may be impeached by testimony by a credible witness that the assailed witness's general reputation for truth and veracity is so bad that he or she would not believe him or her under oath in a court of law. You are further instructed that if, from the evidence presented, you find that a witness has been convicted of a prior crime or crimes, you can consider such only for the purpose of its effect, if any, on his or her credibility of the witness. Accomplice. An accomplice is a person who knowingly, voluntarily, and with common intent with the principal offender unites with him or her in the commission of the crime. If a witness was an accomplice in the crime, then his or her testimony must be corroborated. Corroborating evidence is that evidence entirely independent of the accomplice's testimony, which taken by itself leads to the inference not only that a crime has been committed, but also that the defendant was implicated in it. This independent corroborative testimony must include some fact or circumstances that affects the defendant's identity. Corroborative evidence may be direct or entirely circumstantial, and it need not be adequate in and of itself to support a conviction. It is sufficient if the corroborative evidence fairly and legitimately tends to connect the defendant with the crime charged. It is a question for the jury to determine whether an accomplice's testimony has been sufficiently corroborated. Accomplice testimony cannot be corroborated by another accomplice's testimony. Evidence which merely casts a suspicion on the accused is inadequate to corroborate an accomplice's testimony. In this case, the court charges you that the witness, Jason Autry, was an accomplice in this alleged crime, and before the defendant can be convicted, you must find that this accomplice's testimony has been sufficiently corroborated. Evidence of other crimes or bad acts. If, from the proof, you find that the defendant has committed crimes or bad acts other than that for which he is on trial, you may not consider such evidence to prove his disposition to commit such crimes or crimes as that for which he is on trial. This evidence may be considered by you for the limited purpose of determining whether it provides A, the complete story of the crime. That is, such evidence may be considered by you where the prior crime or bad acts and the present alleged crimes are logically related or connected, or are part of the same transaction, so that the proof of the other tends or is necessary to prove the one charged, or is necessary for a complete account of itself. B, motive. That is, such evidence may be considered by you that tends to show a motive of the defendant for the commission of the offense presently charged. C, the defendant's intent. That is, such evidence may be considered by you if it tends to establish that the defendant actually intended to commit the crime with which he is presently charged. Such evidence of other crimes or bad acts, if considered by you for any purpose, must not be considered for any purpose other than specifically stated. Prior statement of the defendant. The court instructs you that if there is evidence of an oral or written statement given by the defendant in this case, you may take it into consideration with all of the other facts and circumstances proved in the case. In considering the statement, it is for you, the jury, to say what weight you will give the statement. You may believe any part of the statement or disbelieve any part of it, and you may believe the whole statement or disbelieve it in its entirety. Confession or admission against interest. Evidence has been introduced in this trial of a statement or statements by the defendant made outside the trial to show a confession or admission against interest. A confession is a statement by the defendant that he committed the crime charged. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to establish the guilt of the defendant, or which tends to show guilt of the defendant or is evidence of some material fact, but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also, consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given to such statement. If you decide a statement was made, you should consider it with all other evidence in the case determining the defendant's guilt or innocence. Stipulations. A stipulation is an agreement. Parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are treated as though these facts are proven. Alibi. The defendant has presented evidence of an alibi in this case. An alibi is defined as evidence which establishes that the defendant was not present at the scene of the alleged crime when it allegedly occurred. If the defendant was not present when the crime was committed, he cannot be guilty. The burden is on the state to prove beyond a reasonable doubt that the defendant was at the scene of the crime when it was committed. If you find from your consideration of all of the evidence that the state has failed to prove beyond a reasonable doubt that the defendant was at the scene of the crime when it was committed, you must find the defendant not guilty. The weight to be given alibi evidence is a question for the jury to decide, considering all the facts and circumstances of the case. The state must prove beyond a reasonable doubt the culpable mental state of the accused. Culpable mental state means the state of mind of the accused at the time of the offense. This means that you must consider all the evidence to determine the state of mind of the accused at the commission of the offense. The state of mind which the state must prove is contained in the elements of the offenses as outlined in the instructions above. Any inference of concealment or destruction of evidence. Any attempt by a person to conceal or destroy evidence is a circumstance which, considered with all the facts of the case, may justify an inference of guilt. While that inference is by no means strong enough of itself to warrant conviction, yet it may become one of a series of circumstances from which guilt may be logically inferred. Whether the evidence presented proves beyond a reasonable doubt that the defendant so acted is a question for your determination. If this fact is proven, this fact alone does not allow you to find that the defendant is guilty of the crime alleged. However, since an attempt by a defendant to conceal or destroy evidence may be caused by consciousness of guilt, you may consider this fact, if it is so proven, together with all of the other evidence when you decide the guilt or innocence of the defendant. On the other hand, a person entirely innocent of a particular crime may attempt to conceal or destroy evidence, and this may be explained by proof offered or by the facts and circumstances of the case. Concealment or destruction of evidence of a crime is not proof of premeditation. Whether there was any attempt to conceal or destroy evidence by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Inferences. court has charged the jury considering an inference that the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. This inference may be rebutted by direct or circumstantial evidence, or both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all of the evidence to determine not only the correctness of the inference, but also the reasonableness of the defendant's explanation. You're not bound to accept either the inference or the defendant's explanation. The state must prove beyond a reasonable doubt every element of the offense before the defendant can be found guilty. When we come back, the attorneys will be given an opportunity to address you in their closing statements. I remind you again that what the attorneys say is not evidence. Since the state has the burden of proof, they have the right to open final argument, followed by defense counsel. Then the state may speak last in rebuttal. At the conclusion of argument, I will address briefly a few administrative matters and some final jury instructions. Then you will retire to the jury room for your deliberation. We're going to take a recess now, take 15 minutes, continue to follow the admonitions I gave you at the outset.